Good evening. Tonight, I will be reporting on suretyship, specifically on sections 177 and 178. Section 117 provides that a contract of suretyship is an agreement whereby a party called the surety guarantees the performance by another party called the principal or the obligor of an obligation or undertaking in favor of a third party called the obligee. It includes official recognizance, stipulations, bonds, or undertakings issued by any company by virtue of and under the provisions of Act Number 536 as amended by Act Number 2206. Surety and guarantor distinguish. So what is a guarantor and what is a surety? A guarantor is the insurer of solvency of the debtor, while a surety is an insurer of the debt. A guarantor binds himself to pay if the principal is unable to pay, while a surety undertakes to pay if the principal does not pay. A guarantor cannot be compelled to pay the creditor unless the latter has exhausted all the property of the debtor and has resorted to all the legal remedies against the debtor, while a surety does not have such rights. The obligation of the surety is primary, while the obligation of a guarantor is secondary. A surety and a guarantor, however, are alike in that each promises to answer for the debt or default of another. Section 178 provides that liability of the surety or sureties shall be joint and several with the obligor and shall be limited to the amount of the bond. It is determined strictly by the terms of the contract of suretyship in relation to the principal contract between the obligor and the obligee. Liability of surety: 1. Solidary. 2. Limited to the amount of the bond. And third, it is determined strictly by the terms of the contract of suretyship in relation to the principal contract between the obligor and the obligee. What are the effects of joint and several liability? By reason of the joint and several liability of the surety, the obligor, either one of them, may be compelled to perform the entire obligation, and payment made by one of them extinguishes the obligation. An illustrative case for this matter is the case of NASCO versus Torrento, GR number L-211009, June 26, 1967, 20 SCRA 427. The court found that since the surety bond expressly provides that Torrento and MISC solidarily bind themselves under the surety bond, it is a suretyship, in which case the provisions of the Civil Code with respect to joint and solidary obligation will apply in Article 1216 of the Civil Code, which provides that the creditor may proceed against any of the solidary debtors or all of them simultaneously, although as a rule, sureties are only subsidiarily liable for an obligation. Nevertheless, if they bind themselves jointly and severally or in solidum with the principal debtor, the creditor can bring action against any one of them, either alone or together with the principal debtor. Surety on financially distressed corporation. The sureties of a financially distressed corporation cannot claim protection from the rehabilitation court. How do we interpret a surety bond? A suretyship contained in a form prepared by the surety must be construed against the surety and in favor of the promisee or construed in the same manner as contracts of insurance. The rationale is that corporate surety differs significantly from individual private surety. First, unlike the private surety, the corporate surety signs for cash and not for friendship. The private surety is regarded as one or someone doing a rather foolish act for praiseworthy motives. The corporate surety, to the contrary, is in business to make profit and charges a premium depending upon the amount of guarantee and the risk involved. Second, the corporate surety, likewise an insurance company, prepares the instrument, which is a type of a contract of adhesion, whereas the private surety usually does not prepare the note or bond which he signs. And third, the obligation of the private surety is often assumed on the basis of the debtor's representation and without legal advice, while the corporate surety does not bind itself until a full investigation has been made. Illustrative case: Layson versus Rizal Surety, GR number L-21250, 31 March 1966. The court held that yes, the surety is liable to the extent of 6,051 pesos and 57 centavos, which amount was found due from the said former administrator. It has already been held that the nature of surety's obligation on administrator's bond, which makes him privy to the proceedings against his principal, is such that he is bound and concluded, in the absence of fraud or collusion, by a judgment against his principal, even though the surety was not a party to the proceedings. In the case of Visayan Surety and Insurance Corporation versus Pascual, the court held that upon application of the prevailing party, the court must order the bond should not respond for the judgment of damages if the surety should contest the reality of reasonableness of the damages claimed by the prevailing party. The court must set the application and answer for the hearing. The hearing will be summary and will be limited to the new defense not previously set up by the principal, as the surety may allege and offer to prove. Surety's right to collect. The sureties or the surety can demand payment from the principal upon the latter's default even before the former has paid the creditor. That's all for my topic. Thank you and good evening.